Can we start, Aditi, please?
We are live, sir.
Greetings to everyone present. My name is Ankit Malhotra. I am the co-founder and president of the Jindal Society of International Law. And today we remember a titan, we remember a giant who has transformed lives, transformed generations of legal thinking and jurisprudence over the course of his practice, and who continues to live in our minds, in our hearts, and also in our thinking. To speak about him, his experiences, and his practice, we have celebrated lawyer and arbitrator and also judge. This is none other than Justice Arjun Kumar Sikri, who started his practice at Delhi High Court in 1977 and handled all types of cases with specialization in arbitration, commercial, and constitutional law matters. He was counsel for various public sector undertakings, banks, and financial institutions. He taught law at the Campus Law Center from 1984 to 1989. In 1997, he was designated as a senior advocate by the Delhi High Court, and in 1999, he became a judge of the Delhi High Court, and in 2011, its acting Chief Justice. In September 2012, he was elevated as the Chief Justice of Punjab and Haryana High Court, and in April of 2013, he was appointed as the Judge of the Supreme Court. He superannuated in March of 2019 as the senior most cuisine judge. Justice Sikri has authored over 4,700 reported judgments in different fields of law. He was chosen as one of the 50 most influential persons in the world who impacted the growth of intellectual property laws for the year 2007 by MIPA. He wrote scholarly articles in various journals and presented learned papers in various national and international conferences. He has several articles in the fields of human rights, commercial laws, arbitrations, and mediation. He is also a visiting professor of various law universities and has been conferred by Doctorate of Laws honoris causa by the National Law University, Delhi on the 31st day of August in 2018, and also by Dr. Ram Manohar Lohia, National Law University, Lucknow in November of 2013. Currently, he is the judge of the Singapore International Commercial Court, chairperson of the Committee for Formulating an Action Plan for Online Dispute Resolution under the Niti Aayog, Government of India members. He's also a member of the Board of Directors of Mediators Beyond Borders International, chairman of News Broadcasting Standards Authority. He's also the chairperson for Grievances Redressal Board, Digital Publisher Content Grievances Council, and ombudsman of Federation of Indian Fantasy Sports. We also have amongst us Mr. Anil Malhotra, who is a practicing advocate in Chandigarh with appearances at various high courts and supreme courts across the globe. He's attained his bachelor's degree from Punjab University and is an LLM from University of London. His focus area is on comparative family and international law, and is taught and has read law at the School of Oriental and African Studies, SOAS. He has 37 years of experience behind him and is a fellow of various international societies and organizations working towards the preservation of human rights and also human dignity. And perhaps the common thread between both our speakers is their staunch respect and reverence for Soli Sorabjee, who was an Indian jurist and served as Attorney General for India in 1989 to 1990, and again from 1998 to 2004. In 2002, he received the Padma Vibhushan for his defense of the freedom of expression and the protection of human rights. In 1971, Sorabjee was designated a senior advocate of the Bombay High Court, and he served as the Solicitor General of India from 1977 to 1980. He was appointed Attorney General for India on the 9th day of March, 1989, up to the 2nd of December, 1990. And then again on 7th of April, 1998, as he held the post until 2004. In March 2002, Mr. Soli Sorabjee received the Padma Vibhushan for his defense of the freedoms of expressions. But during the emergency, Sorabjee provided legal services to the political prisoners. Later, he worked on the Citizens Justice Committee, which represented the 1984 anti-Sikh riots pro bono. In March 2006, he was also appointed as an honorary member of the Order of Australia for service to Australia-India bilateral legal relationships. I can continue for the rest of time, but since there is not much time, there is a paucity of time. I now invite Justice A.K. Sikri to please kindly share his address in remembrance of someone who has inspired all of us so deeply. Sir, the floor is now yours.
Thank you, Ankit, and Mr. Anil Malhotra, who is with me on this program. And good evening to all the listeners who have joined this and are listening to this particular and attending this program, I would say that, and listening to us. First of all, let me congratulate you that you have given very thoughtful consideration as far as Soli's lecture in the name of Mr. Soli, as it happens to be his birthday today. And so it is a befitting tribute to organize such a lecture in his memory and remember him on his birthday. And at the same time, let me thank you that you have chosen me for this privilege, and you have accorded me this privilege to be here today and to be speaking in his honor. No doubt, Soli Sorabjee was a multifaceted personality. We had come in contact with each other very closely, and many evenings which we spent together, thanks go to Mr. Anil Malhotra, who is sitting here, who would organize those dinners in India International Center, and when we would discuss so many things with each other, and the kind of affinity and the kind of bonding which developed between two of us over a period of time, I would say, going by his age, who was like an elder, like a guide, like a mentor, because when I started practice, he had already established himself, and we used to look upon him for guidance, for so many other things, and I must have engaged him as a senior so many times, must have gone to him for opinions so many times. And it is the uniqueness of this profession that when I became judge in the High Court and then in the Supreme Court, he was appearing before me and arguing before me. And but that apart, one thing which I would say before talking about him and about the topic of human rights, which I intend to cover today, because that was a topic very dear to him, and his contribution in the field of development of human rights is stupendous. And only one thing which I would like to say, that today is his birthday. My birthday falls on 7th. That was day before, 7th March. In between, yesterday, 8th March was International Women's Day. And once he talked to me and he told me that, look, women's are in between. On one side, I am there. On other side, you are there. So we both have to be the protector of women's rights. So I'll protect these rights as a lawyer. You have to protect the rights of the women as a judge by your pronouncements. And it was really a very profound statement. In a way, he was telling me and he was reminding me of my duty as a judge when it comes to the protection of human rights of women. But with this, let me, as I said, that the topic which I have chosen is the human rights and the way human rights have been universalized over a period of time. So that is what I would be covering, and and it would be where I would be referring to Mr. Soli Sorabjee number of times in between as far as his contribution is concerned. But let me start with my tribute to Soli. I will, for rest of my lecture, I will just call him as Soli. I say that sometimes words of praise are not enough. Sometimes they are redundant. And sometimes even the most gifted of us fail to manage a fitting tribute. A person of Soli's stature, who has been a fearless lawyer, a spirited champion of human rights in the mind, and a musician, a poet, and a crusader of sorts at heart, often makes us grope so helplessly for words of appreciation that language itself seems deficient. The tap of creativity simply gurgles and falls dead. His mesmerizing persona and charismatic aura are best described by nation's beloved president APJ Abdul Kalam in the following words. This is the message which he had given on 28 February 2005 for the book Constitutionalism, Human Rights and the Rule of Law, Essays in the Honor of Soli Sorabjee, and I'm quoting from there. I have known Shri Soli Sorabjee to be an outstanding person with sterling qualities of head and heart. Not only is he a legal luminary par excellence, I have also found him to be a very sensitive individual with a cultivated sense of culture and art, especially jazz music. He has always come across as a shining example of legal acumen with a humane face. These two words are really profound, with a humane face. Soli Sorabjee was epitome of what an ideal lawyer should be, and his life is a perfect example for the young bar to emulate, equally young students to emulate, who are, we can say, are the budding lawyers. After his designation as a senior advocate in the year 1971 by the Supreme Court of India, his career graph soared to greatest heights, and he never looked back. He scaled Himalayas of legal profession by reaching pinnacles as he became India's Attorney General from 1989 to 1990, and again from 1998 to 2004, as was communicated to you or described to you by Ankit. In his long professional career, spanning over almost 7 decades, Soli excelled in every field of law. As a renowned human rights activist, he was appointed by the United Nations in 1997 as a special rapporteur for Nigeria to report on the country's human rights status. From 1998 to 2004, he served as a member and later as chairman of the UN Subcommission on the Promotions and Protection of Human Rights. He was also a member of United Nations Subcommissions on Discrimination and Minority Protection. Additionally, he served as a member of the Hague's Permanent Court of Arbitration from 2000 to 2006. Sorabjee worked with the Citizens Justice Committee and took up cases pro gratis for victims of 1984 anti-Sikh riots. Queen's Counsel Anthony Lester remarked eloquently in his essay on Bangalore Principles that what may be less well known in India is the selfless service Soli Sorabjee has given in promoting the use of international and comparative human rights laws across the Commonwealth and beyond. Soli played a key role on helping InterRights, the International Center for Legal Protection of Human Rights, the abbreviation is InterRights, to develop what have become known as Bangalore Principles, a series of international judicial colloquia. It is there fitting to describe the process by which those principles have been developed and applied, thanks in no small measure to Soli's efforts. 1998 marked the 10th and final years for a series of influential judicial colloquia, which gave the opportunity for members of Commonwealth countries' senior judiciary to discuss ways in which judicial protection of human rights in the Commonwealth could be strengthened. The final judicial colloquium in 1998 was held in the same place as first in 1988, namely in Bangalore. The 6 other colloquia in the series were held in other countries. Each has been organized by Inter-Rights, together with Commonwealth Secretariat, and Soli's participated in several of them. Soli, a profound alumna of St. Xavier's College, Bombay, appeared on behalf of its Ahmedabad sister college to challenge operational constraints. He convinced the court to affirm minority institutions' autonomy. That was a landmark judgment in those old days. Thereafter, many judgments have come. That St. Xavier's College judgment is very well known. His contribution in the field of religious and linguistic minorities to administer educational institution, which was held in St. Xavier College, became a path-breaking judgment. But the contribution or standing up to human rights during difficult period, which is really, I would say, a test or a yardstick to test the mettle of a person, that was emergency days. The available Sorabjee frequently volunteered his service for free, referred to as pro bono. Throughout the emergency, he offered legal representation to a large number of political detainees made captives under the repressive MISA. It was a trying time and he lived in fear of being imprisoned. Kumi Kapoor writes, she has written this, which is very interesting, that once Soli joked with her about his young son, Hormezd, being frightened of bringing shame to the family if he was taken to jail. Palkiwala and he were taken aback by the Supreme Court's exceptional suspension of fundamental rights, including the right to life during emergency in that 4-1 decision, which everybody knows about, that case of ADM Jabalpur. Soli always remained critical of human rights violation during emergency. He wrote in one of his pieces entitled Human Rights During Emergency that without remedies, rights are useless. It is critical that the rights to legal remedies, particularly the writ of habeas corpus, be not only guaranteed by the Constitution, but also stated inalienable during times of national emergency. The great value of habeas corpus cannot be overstated, and its availability in an emergency is critical. This would ensure that a competent court of law has sufficient supervisory jurisdiction to decide whether detention is legal and valid. It should also facilitate detainees' appearance before the court, which will go a long way towards preventing torture, humiliating and inhuman treatment, and other physical or psychological abuses to which detainees are frequently subjected to. In any case, where production is plainly impractical or damaging to public interest, the government must inform the court of the location of custody. Such an important exposition of human rights during emergency, which he said so in his essay which I have mentioned about human rights during emergency. Soli has discussed extensively in the aforementioned article what our founding fathers throughout the emergency clause being included in draft constitution. The major arguments voiced by H.V. Kamath, Pandit Hridayanath Kunjuru and Mahabir Tyagi have been mentioned in that article. It's a worth reading. He goes on to discuss the example of American Convention on Human Rights, which is unique among human rights instruments in this regard because it is the first to include judicial safeguards necessary for protection for non-suspendable rights among the rights that may not be suspended. Let me hear, that is what his contribution is, and I will come further and keep mentioning him. But come to our constitution. and then I will come to the universalization of human rights. Since I have chosen that aspect also universal, because I am speaking at a forum which is a society on international law. But let me start with our Indian Constitution. And before that, I will say, uh, you see, human rights, they are mentioned in various constitutions. All these constitutions, except American constitutions or one or two constitutions which may be 200 or 250 years old, most of the constitutions have come up in last century, in last 70 to 100 years, including Indian constitution. And in each country's constitution, there may be chapter, there may be, provisions about human rights. So every country ensures that kind of human rights to its own citizens. But then the concept of universal human rights, I think it started, or it got developed, or it was initiated after Second World War. It was because immediately the Holocaust of the Second World War and the casualties and the number of people who lost their life, this was tremendous. So therefore, the most important lesson which was learned as a result of Second World War was the realization by the governments of various countries about the human dignity which needed to be cherished and protected. That was realized. No, it is for this reason that the UN Charter 1945, adopted immediately after the Second World War, dignity of individual was mentioned as the core value. Now, in UN Charter, you are talking about the dignity of individual, and UN Charter, which represents all the countries who are the members of UN, United Nations. So therefore, the almost contemporaneous Universal Declaration of Human Rights 1948 echoed the same sentiments. And once we had the Universal Declaration of Human Rights, that was where the seeds for universalization of human rights, or human rights as universal value, came to be established. Now, this finds, and what I want to say here is that and that is my hypothesis, which I have said in so many judgments also as a Supreme Court judge, that the fulcrum of these human rights is human dignity, that every person is to be seen with dignity. If you see the Indian Constitution, but I'll come to that, but before that, as far as the concept of human dignity, or the mention about the human dignity is concerned, it is there in various documents of UN, including in Universal Declaration of Human Rights. Article 3 of the Geneva Convention explicitly prohibits outrageous upon personal dignity. Outrages upon personal dignity. There are provisions to this effect in International Covenant on Civil and Political Rights, Article 7, and the European Convention of Human Rights, Article 3, though implicit. However, one can easily infer the said implicit message in those documents about human dignity. The ICCPR begins its preamble with the acknowledgement that rights contained in the covenant derive from the inherent dignity of human person. That is what it says in quote. And some philosophers say the same thing. Even if this is not a connection between dignity and law as such, it certainly purports to identify a wholesale connection between dignity and the branch of law devoted to human rights. Now, if this was a lesson learned because of the Holocaust, and which the humanity suffered during Second World War, and we know insofar as Indian Constitution is concerned, India got independence within 2 years of this 1945, that is in the year 1947, when immediately thereafter the Constituent Assembly was constituted to draft Indian Constitution. So therefore, these constitutional values were very much within the mind of Indian framers of the Constitution. And that is why one complete chapter that is chapter 3, which is devoted to human rights, or what we call fundamental rights. And in part 3 of the Constitution, though part 3 of the Constitution, if you say, does not mention dignity or human dignity as one of the fundamental rights. Dignity is the expression which appears only once in our Indian Constitution, that too in preamble. And preamble which says this, we know it, that the preamble proclaims that India is constituted into a sovereign, socialist, secular, democratic republic, and it is aimed at securing to all its citizens justice, liberty, equality, and fraternity. While talking of fraternity, the preamble states fraternity assuring the dignity of the individual and the unity and integrity of the nation. So, along with fraternity, word dignity comes. But what has happened over a period of time, if you see, this dignity is read into Article 21 of the Constitution, where although this the plain language of Article 21, if one reads in a pedantic or narrow sense, it only says nobody shall be deprived of his life and liberty except by the process of law. Initially the issue was whether process means due process, only process, which is now in 1950 it was argued that it should be read as due process, like in American Constitution, which was not accepted. But then it was accepted in 1978 judgment in Menka Gandhi that yes, it has to be due process. But the more important thing which I want to say is that while interpreting right to life and liberty, the court expanded that right to life means right to live life with dignity. And the moment this expression dignity has been used in the interpretation of Article 21, and saying that right to life does not mean a mere animal existence, from there flowed, and that is what we know over the last 50 or 60 years, when various judgments have come, and how the scope of Article 21 has been expanded to include at least 40 rights, even only from Article 21. So that is what the Supreme Court has done. And if I may say so, from this, without stating much, and then coming back to this, but when I say that the dignity is the fulcrum of the human rights, which was very dear to Soli, and when I'll come to that, if you see the judgments, DK Basu case, when it talked of the person at the time of arresting, that what are the precautions which are to be taken, and why even the person who is an accused and who is brought before the court after his arrest, but his due dignity is to be maintained. And what are the precautions which are to be taken, or what are the rights which are to be given to such a person. Sunil Batta's judgment, where the brutal assault by head warden on a co-prisoner, and Sunil Batta, who was himself facing life imprisonment at that time, was convicted of heinous crimes like murder. He had come to the court, and the court said that yes, that brutal assault, merely because a person is a prisoner, merely because he has been convicted, that does not mean that he loses his dignity. And therefore, the rights, which are the fundamental rights, will be Article 21 also, to live with dignity, even in jail, would be there, and he cannot be, these persons cannot be assaulted like that. Prem Shankar Shukla case on handcuffing of the prisoner, that why normally, one can say that yes, a person who has committed crime, why he should not be brought handcuffed. But again, the dignity in that even a person who is accused of a crime was seen. And when I'm saying so, if you see, read the judgment, they all talk about the human guarantees. Like in Prem Shukla case also, the court said the guarantee of human dignity, which forms part of our constitutional culture, and the positive provisions of Article 14, 19, and 21 spring into action when we realize uh, that to manacle man is more than to mortify him. It is to dehumanize him, and therefore to violate this very personhood too, often using the mask of dangerousness and security. That is what, that the person may be a dangerous criminal and it is because of security we are handcuffing him. The court said no. And of course, laid down the guidelines under what circumstances, under exceptional circumstances, you can do so. That Francis Mullen case, that where the entitlement of a détenu under the Coffee-Posa Act and his right to be interviewed by a lawyer of his choice, they were recognized. Then, if you talk of, when we talk of a case of, say, bonded labor, and in that Bandhua Mukti Morcha, when the judgment was given, and the court in that case developed a relationship between the fundamental rights and directive principles, elevating some of the directive principles, reading those into Article 21. And it was such a wonderful transformation by the Supreme Court. And they said that that they have also right to live with human dignity. Again, that is the word used, enshrined in Article 21, and therefore you cannot have this bonded labor. Then the judgments which have come on the rights which are given to scheduled castes and scheduled tribes. Then the judgments on persons' autonomy in Shrimati Selvi versus State of Karnataka, that you cannot subject a person to narco analysis, polygraph examination, or brain electrical activation without his or her consent. This is again based on the human dignity. So there are so many judgments thereafter. If you see the judgments on which the Supreme Court has given and expanded on the transgenders, rights of transgenders, in the Nalsa case, rights of persons who are handicapped persons in Jijabhai Ghosh and other such cases. These and there are examples which will go on, and I need not say much, except coming back to a very one important case, that is right to privacy, which was a debate, and it is a recent judgment of 2018, and whether right to privacy is a fundamental right at all or not. There were judgments, contrary judgments earlier. Therefore, the matter was referred to 9-bench judgment. And in KS Puttaswamy 1, the 9 benches, all judges have written their separate opinion, but they all concurred and unanimous opinion that right to privacy is a fundamental right. And the manner in which the concept of dignity in right to privacy is, discussed is a treat to read. And in this context, if you see in Puttaswamy's case, Soli had argued that this loophole should be filled by using the classical, because when it is, the argument was that there is no such right guaranteed under, it can't be read in 21 or the Supreme Court has interestingly said that it can't be confined only to 21. It can be read in 14, 19 and 21, all these together. And the argument of Soli was that if there is some loophole, it should be filled by using the classical case of Griswold versus Connecticut, where the United States Supreme Court had used a new judicial technique of deducing new human rights. To give some background, Connecticut's General Statutes 1958 through sections 53 and 54 made the use of contraceptives a criminal offense. That use of contraceptive would be a criminal offense. The police were empowered under the statute to rush into a bedroom and examine the sacred confines of marital beds for telltale evidence of contraceptive use. So that kind of law was passed. I mean, on the face of it, such an abhorrent law. But the statute, it was argued, violated the right to privacy. The US Bill of Rights makes no clear mention to privacy like Indian Constitution. Nevertheless, Justice Douglas derived privacy in their decision on the grounds that, and I quote, particular guarantees in the Bill of Rights have numerous produced by emanations from those guarantees that contribute to their life and substance. Numerous assurances establish zones of privacy. This argument was affirmed by the Indian Supreme Court in Puttaswamy case, and that is the contribution of Soli insofar as this judgment, landmark judgment, is concerned. So I would quote here one thing more, having a nostalgic flashback of his days in the courtroom, striving for justice and to mark his efforts towards human rights. We must reiterate some of his words he delivered in a lecture on the expansion and protection of fundamental rights by judicial interpretation and intervention at the West Bengal National University of Juridical Sciences, NUJS as we say, and I quote the words of Soli here. In countries like India, where fundamental rights are violated every day, whether in flouting of labor laws, illegal detentions, discriminatory actions, and other violations, one may wonder what response may be given to a cynic's taunt about the futility of fundamental rights. The answer is that guaranteed fundamental rights empower citizens and groups fighting for justice to approach the court. It also provides opportunities for vindicating the rule of law. It also establishes norms and standards which can be used to educate people to know, demand, and enforce their basic rights. It has a salutary effect on administration, which is made aware that it has to conform to the discipline of fundamental rights. Above all, a Bill of Rights, Part 3, enumerating fundamental rights, is a constant reminder that the powers of the state are not unlimited and that human personality is priceless. That was the just see the words in which so beautifully he has described the human dignity, and on the basis of which the Supreme Court has expanded from time to time. I say, and I always maintained in my judicial career also, that no doubt judges laid down law by interpretation, but then the support which in the process is given by the lawyers in guiding the judges, I'm using intentionally the expression guiding, that many times a good lawyer like Soli, they guide the judges as to what path you should take in a particular case. And the contribution of the lawyers in expanding the human rights, that ultimately judgment may be by the court, but the contribution of the lawyers is no less. So the lines I have quoted, these lines epistle the commitment of Soli towards protection of human rights. For him, it was not just a virtue, rather it was an article of faith, a faith which he stood for always. Now, I started with this, as I mentioned, about international covenants and UN declaration and how the universalization of human rights took place. As most scholars of international relations are aware, there has always been a theoretical debate within the discipline, drawing on elements of philosophy, psychology, and even economics, about whether we live in an international society of states, that is, a community that feels connected, accepts a set of common guiding principles, and is composed of member states willing to adhere to rules and norms of behavior, or whether it remains merely a system of states. Of course, so much is said in UN charters, so many charters, which I have, some of them I have said. And from 1945, today, more than almost 77 years, when UN was created, whether it has served its purpose over a period of time, or whether we have to introspect about the whether UN body has been able to uphold these human rights in various states. And recent example of Ukraine war, which is happening even today, is an eye-opener where the role of UN comes for, I would say, criticism, or there has to be an introspection on that. And therefore, whether these are merely what is stated in these documents are merely the rhetorics, of the rule-based order, or whether we are able to achieve this order. I would not say much about this, but um, something about the which I would say as far as the wars are concerned and how they violate the human rights, and what is happening in Ukraine also, how the civilians are treated during this period, and how many civilians are killed. That is, and it is Ukraine is not the only example. There are so many such wars which have taken place even after 1945, and the way the human rights are trampled with in these wars and during this period, that is one thing which we have to see, and we have to, what can be the world order today. uh, if I may say and quote here, use of force is cruelty, and you call it lawful killing during war. That is what happens. Forget not what your own situation will be when you will be asked to account for in the court of natural justice, that is, in the court of God. This is the why and what, why of the what, the innermost expression of the humanitarian spirit, particularly the principle of unnecessary sufferings, enshrined in Article 2, Paragraph 4 of the United Nations Charter, that urges the nations to refrain from the threat or use of force in their international relations. The eternal law of nature, as described in Kabir's couplet, may or may not be that what I mentioned earlier was in quote was Kabir's couplet. In English, I translated that. So what I'm saying is that the eternal law of nature, as described in Kabir's couplet, may or may not be the realization of people of any other state. However, there is a belief in Indian civilization history, at least intuitively and consciously, that what you do to others, including the use of force upon others, you will have to account for it in the final analysis of natural law. But when we discuss the tyranny of war in history of mankind, as nothing has played more havoc in the history than war. Nothing tramples over the dignity of human than war. Nothing shakes the conscience of human than war. And yet, the only legal mechanism of protecting human dignity in the war and as against the war is the law of armed conflict, and also called the jus in bello. This has further divided itself into two branches called Hague law and Geneva law. Hague law comprises various Hague conventions that regulate the conduct of armed conflicts, that is, seeking to regulate the means and methods of warfare. Geneva law, also called international humanitarian law, comprises various Geneva conventions that seek ensure minimum standards of treatment for the victims of armed forces conflict, that is, the wounded, the sick, the prisoners of war, the civilians. As Professor O'Brien aptly observed, the distinction between both these schools is not clear cut. It simply, according to him, serves to indicate the distinction between operational matters and questions of humanitarian or human rights concern. And of course, I can say much and go on as to what has been happening in last few years, and be it 9/11, be it, and because of that, how the invasion took place in Afghanistan and Iraq, and whether it was justified or not. And there are, recently, as I've said about the what is happening in Ukraine, I'm not going into those, but what I am saying is that they undermine all these things, undermine as far as human dignity is concerned. And here, projecting and coming out for peace and talk about peace, and stating about the violation of human rights of the people, of the civilians during war, the way it was done by Soli, we remember Soli really very badly today. So respect for Soli, I would conclude by saying respect for Sorabjee's contribution to the functioning of human rights in emerging world order originates also from his off-court contribution in the form of erudite pieces in newspaper, some of his lectures, etc., or some of his writings I have already mentioned. And it is because of this reason that he was the ardent supporter of human rights at universal level. And because of this, he received international acclaim for his unflinching defense of human rights. He was nominated as chief prosecutor of the Yugoslavia War Crimes Tribunal by UN Secretary General. However, the Security Council ultimately rejected this nomination. When Sorabjee was designated as Special Rapporteur for Nigeria by the UN Chief Prosecutor Commission on Human Rights in 1997, initially the then Nigerian government resisted his visits to the country. It eventually bowed to pressure and allowed Sorabjee and his crew to enter. They issued a full report outlining their findings and making suggestions about civil freedoms, gender equality, and judicial independence. It's worth noting that the rule of law is not one-way track. It imposes constraints on both the government and individual citizens. That was his message. If the basic ideals of the rule of law are to become a reality in governance as well as in our daily life, laws are undoubtedly important but insufficient. And again, I finish with this by saying that we need the persons like Soli, the soldiers of human rights like Soli, who cherished and valued human rights based on dignity of persons, of each and every person, irrespective of the status of that person in the society, or his financial status, or caste, or religion, or sex, and particularly the rights of the persons who are underprivileged, who are marginalized, and rights of women. And he valued the dignity in each living creature. So with this tribute to Soli on this day, I rest my voice.
Thank you so much, sir. I have 7 pages full of notes. Thanks to your extremely insightful and eloquent speech. And I now invite our second speaker to share his perspective and his relationship with the Titan who we remember today. So.
You are muted. Unmute yourself.
Honorable Justice Sikri, esteemed listeners, there could not have been a more befitting tribute to Mr. Soli Sorabjee, whose 92nd birthday we celebrate today. When I messaged Zina ma'am in the morning, she said Soli would ordinarily be deciding what clothes to wear in the evening and looking forward to his party. I have attended n number of them. His 91st birthday said 91 and not out. So I said, sir, you will clock 100. He will clock 100 in our hearts. He lives in us. He lives with us, in our memories, in our hearts. I'm at a loss of words because the erudite and detailed exposition by Justice Sikri sums up the personality of Mr. Sorabjee. Human rights and human dignity were two words which were synonymous with the two words Soli Sorabjee. This is how I best encapsulate the three words and say he was a champion of human rights. And I could not add more to what the detailed discussion of law Honorable Justice Sikri has put forth. I put my words in a different perspective. And I begin by quoting Soli Sorabjee, Life and Times by Avinav Chandrachud, who beautifully describes him, saying, how does a Parsi lawyer, deeply influenced by the principles of Roman Catholicism, fall in love with a bhaiya and go to become the Attorney General of India for a Hindu nationalist BJP government? How does a boy with a broken leg who studied in a Gujarati medium school and who lost his father at the tender age of 19 go to mount a heroic defense of the Janta government's decision to dissolve the Congress state legislatures in the Supreme Court in 1977, and Soli came to be known as Mr. 356? How does a newspaper columnist who admires Jawaharlal Nehru, who criticizes the BJP for being obsessed with demolishing mosques and advises them to replace the word Hinduvata with Bharatavata or Indianness, get chosen by Prime Minister Atal Bihari Vajpayee to represent the government in the Supreme Court in many cases, including the Ayodhya case? How does a lawyer with a humdrum excise and law taxation practice, whose grandfather sold horse-drawn carriages in Mumbai, became a UN human rights rapporteur and repeatedly defended the fundamental right to speech and expression in the Supreme Court of India? Dear listeners, this was the man, late Mr. Soli Sorabjee. A fiercely independent personality, Soli lived his life by his rules and played the game as he wanted to. Distinguished authority of law till eternity. I have been in touch with him till the age of 91, with him and Justice Sikri being part of all our 9-book releases with a foreword or a preface or a speech. He was a erudite, apolitical scholar, encyclopedia of deep-rooted infinite wisdom, personality full of instant wit and humor. He would stop in the middle of a road in a street in Australia or while hailing down a cab in London, crack an anecdote and recollect something absolutely out of the blue. A prolific writer, a jazz lover, an ardent protector of freedom of speech, a protagonist of personal liberty, a human rights watchdog. His traits were endless. Poetry, literature, architecture thrilled him. Witty, passionate, exuberant, Mr. Soli Sorabjee, fondly called Soli, though I could never call him Soli for the respect I had for him, lived life to the full. Mimicry was an art. He loved gifts. I remember when he passed away, there was a huge collection of books which he never parted with. And as Zina ma'am described it, she often asked him, what are you going to do with these books? Thankfully, Professor Rajkumar, the Vice Chancellor of Jindal Global University, came to her rescue, and he sent an army of people, packed them very nicely, and those books have found a new home, the Jindal Global University Library, where I think Mr. Sorabjee's memory still lives. And the university has started a scholarship in his honor, and I think a chair should be established in his honor, because he is a man who will be remembered through his work. Twice Attorney General, one Solicitor General, advocated for justice, zest and zeal to promote budding lawyers and espouse emerging young entrants. He was held in high esteem by the legal fraternity. He was very fair to the opponents, very respectful to judges, very polite and gentle in courts, and equitable relief flowed his way. He never had qualms, no regrets, remained a paragon to emulate. He respected views and opinions. He never deterred dissent. Discussion was always free and fair. He imbibed values and taught tolerance. He taught humanity. But at the same time, he loved good food, he loved good music, he loved good drink. Gastronomic delights were his favorite. Pumila cheese, Thornton chocolates, Old Par whiskey, Dhunsak, Scottish shortbread, Kiani biscuits were his favorite. And bookstores were whiskey shops. Mr. Sorabjee believed that lawyers should not limit themselves to their profession and cultivate interests in areas such as literature, public affairs, and human rights. He used to remind law students and young lawyers of the famous quote that you will always be a mason if you confine yourself to law alone. You will be considered an architect, if you study literature and history, develop a taste in music and arts, and understand and implement the legacy that we inherited from the great leaders of the bar. Not just an advocate, Mr. Sorabjee was a prolific writer. Most of us do not even extend beyond reading law books, but the man he was, I think only 25% of his energy on a day would be spent on law. The rest would be his passions, his hobbies, his music, his another interests. He was, Mr. Sorabjee was simply one of the kindest and the most dignified human being one could ever meet. He was a passionate supporter of human rights who brought insights and vision, as Justice Sikri explained, but simultaneously lent deep integrity, warmth, and laughter. I also was to quote the paragraph which Mr. Sikri picked up from his lecture at WBNUGS, and I think that paragraph is perhaps the gist of human rights and the evolvement in so many. It's a wonderful paragraph. I read it 6 times, put highlighters and underlined it, but Justice Sikri very well quoted them. And if I think Justice Sikri on the bench finds wisdom in it, I'm sure it must be valued for worth its weight in platinum. Mr. Soli Sorabjee was an exponent of free speech, and he raised his voice against students of Jawaharlal Nehru University being slapped with sedition for expressing their interest. And he walked up to the Supreme Court and sought the release of all those students. That was the man. A man of sharp intellect and solid integrity. He will be considered to be one of the greatest legal titans of India. And he will be remembered of its contribution to the rule of law in the best democratic traditions for respecting human rights, especially the weakest. It is ironic that we need Soli today more than ever in the present situation in India. We need Mr. Sorabjee's likes in the Supreme Court and in the High Courts much more than he was when he was here. Maybe he has inspired a commitment to human rights in each one of us. If we were to be at least even 10% of what he was, I think we would achieve a milestone. I have traversed continents, conferences, tabled discussions, open houses with him, and I gained a lot in the last 20 years of his life. I will miss him, and I will commit to the Sorabjee family to celebrate his birthday every year till I breathe my last by holding a lecture to commemorate his values so that the generations to come remember him for eternity. Thank you.
Thank you. Thank you so much to our respected speakers for sharing their thoughts with respect to how they remember, recollect, and rejoice in the name of a titan. And I must confess, I grew up listening about Soli uncle as I knew him. And when I joined the university, I joined the center, which was then moderated and chaired by the university's former registrar. And there used to be a quote over there. It's still there. And given the vice chancellor's endorsement of the Gandhian perspective, this quote is read by Gandhi, who said, and I quote Gandhi here: "Live as if you were to die tomorrow. Learn as if you were to live forever." End quote. And I think that was the integration of life and a celebration of the law with which Soli uncle lived by. And such accounts and such similar accounts were encapsulated in this wonderful book, of a special copy which I keep in my office space here. And we're so grateful to the entire family for who showered us with so much love and so much integrity and so much of respect. If Uncle was here today, I think he would have said Slava Ukraine. I think a solemn declaration and a solemn pledge to the protection and emancipation of human rights with which we all live to and which we all abide with. We miss Uncle deeply, and in his memory, at least in our household, we will cut a Shrewsbury cake and celebrate and rejoice in his name. I thank everyone present over here for taking out time. Respected sirs, we're so grateful for your time and your extremely insightful words. We're so thankful. We're extremely honored and delighted. Sir, thank you so much. Final words, sir. Sir, we can then
Your final words.
My final words.
Yes, sir.
I'll only say, since this is meant for student, and one of the most prestigious, I would not say one of the most prestigious law university in India, and one of the premier in the world today. And the students must read the life of Soli, the contribution of Soli. You will learn a lot, because in these formative years, reading the stories, and as Ankit has shown that book also, of such stalwarts, they are a source of encouragement. They are a source of even inspiration. They will inspire you a lot. They will guide you a lot. So therefore, apart from other, books which you have to read as law courses, please go through the life and the contribution of Soli, insofar as various branches of law are concerned. It's not only human rights, but yes, human rights was dear to his heart. So, and therefore we spoke about human rights. But he was an outstanding lawyer, and as Anilji has rightly mentioned, that if you are confined only, and that those were his words, to law only, you are a mason. But if you have interest, other hobbies as well, like he had in music and reading other than law, etc., then you are an architect. So become an architect. This is one leaf from his life or from his book, which you can emulate today itself. So that would be my message to the students. Thank you.
Thank you, sir. Thank you very much for coming, sir. Thank you for the lecture, sir. It was most insightful. Thank you, sir.
Thank you. Thank you so much, sir. We're so grateful, and we look forward to our future discussions and correspondences with you. And we will bother you further now, which we sincerely hope will be a duty with which we will be blessed to have your presence and participation. Thank you so much, sir.
My pleasure. Thank you.
Thank you, sir. Thank you, sir.
हेलो अंकित जी हेलो